Right, ladies and gentlemen, it's that bewitching hour. Shall we make a start? Just get through the preliminaries first of all, if I may. There are no fire alarms scheduled for this evening. Therefore, if the alarm sounds, please evacuate the building immediately. The fire exit is located at the rear of this room. Go down the back stairs and meet in the War Memorial Park. Just to remind you that this meeting is being webcast. And can I remind you about mobile phones? If you happen to have yours switched on, could you turn it off, please? Thank you. Right, I think you all have an agenda. First item is apologies and substitutions. The only apology we have is from Councillor Spillane. And on the matter of substitutions, I believe that Councillor Pearce this evening for Councillor Washbourne. Is that right? Good, thank you. Just one little departure from the agenda. I think as there's a few additional faces around the place, I'll just invite Mel to introduce the team who's with her this evening.
Thank you, Chair. So hopefully you all know me by now. So my name is Melanie O'Sullivan. I'm the Deputy Monitoring Officer. To my left is Adam Mallins. He's a member of the Legal Services team who's been supporting me with the work that's on the agenda this evening. And then we have Sarah Shepherd, the Corporate Communications Manager there, who's going to assist with the media protocol. Just to let members know, to the back of the room is Gina Clark. Give her a little wave. Gina is going to be replacing me because as most of you are probably aware, I am due to go off on maternity leave very, very soon. So Gina is going to be appointed the Deputy Monitoring Officer in my absence.
Thank you very much, and we look forward to working with you, Gina. Okay. Declarations of interest, I don't think we have any. No. Urgent matters, I haven't been notified of anything. No. Appointment of Vice Chairman. This is a matter that we haven't been able to deal with before, as this is the first Standards Committee meeting in this municipal year. I gather that Borough Councillors have been having discussions about this, so can I hand over to whoever, please? Councillor Parker.
Thank you, Chair. I'd like to nominate Councillor Dan Putty for the position.
And I'd like to second Councillor Dan Putty.
And is that the... you're happy with that, are you, Dan?
It's a pleasure to accept.
Good. Okay. Are you happy with that? Good. Okay. Would you like to come and join us then? Very welcome to see you again. Obviously, Dan has been a member of the Standards Committee for a number of years and is the immediate past Vice Chair, so good case of continuity. Okay. The next item is going to test your memory because it's the minutes of the meeting that was held 6 months ago on the 26th of January this year, paper A in your bundle. Are they agreed? Yes? Okay. Thank you very much. Which takes us to the first substantive item on the agenda, which is paper B in your bundle, the review of standards arrangements for dealing with complaints. I'd like to ask Mel to introduce this item, and then we will move on into the various stages of discussion after that. Mel?
Thank you, Chair. So just to provide a bit of background in relation to the work that's been undertaken, because it's been going on over a period of time. So this work was undertaken following an audit recommendation and experience from working with the current arrangements. It was decided that we would review the existing arrangements that we've got in place for dealing with complaints that are made against councillors. In order to facilitate this work, a working party was set up from the Standards Committee, which you may recall back in January, and the members of the working party are here this evening. The initial meeting of the working party scoped out what was identified as the key issues around the arrangements that are in place. These were time limit for dealing with complaints, length of time to deal with a complaint, appeals process, sanctions, whether it was appropriate to retain the two separate procedures, and the role of independent members. The Working Party looked at each area in turn, and as well as reviewing the arrangements, it also attended group meetings to discuss it with the various groups. The first issue that was discussed was in relation to time limits, and as you may be aware, at the moment our current arrangements don't attain a time limit for when a complaint can be made. So we have had complaints where the complaint has been made about previous conduct that sometimes has happened years before the actual complaint has been made. So it was considered necessary to look at imposing a time limit, and in all the work we did around this area, we've looked extensively at what other local authorities are doing and what their arrangements have in place. When we looked, the common factor in terms of a time limit for complaints was 6 months. So the Standards Working Party chose to adopt the 6-month time limit, but determined that an exception would be inappropriate if there is, serious conduct that needs to be investigated. The big issue for the Standards Committee going forward, and is something that we've all been working to, is around the length of time it takes to deal with complaints and trying to improve on that. So that was a big issue for us, and one of the things that the Working Party tried to do was to set a time limit in which a complaint should be determined by. However, having looked into that, it's very difficult to do because each complaint is different, and whereas one complaint could be very quick and easy to resolve, another complaint might take a lot of investigatory work, and it shouldn't be that we set a time limit that prevents us from investigating complaints fully and completely. So what we've done is added in a criteria to allow complaints to be resolved at an early stage so that less time is spent on particular types of complaints. And we've also looked at how I reuse the resources of the legal services team, and we've expanded the scope of that resource, which hopefully will help decrease the amount of time it takes to deal with complaints. The next issue to look at was an appeal process, and again we looked at other authorities and whether they had an appeal process in place. Many authorities didn't have an appeal process in place and would rely on the provision of the local government ombudsman if somebody was dissatisfied with the outcome of a decision. However, when the Working Party considered this, it did think that an appeal was appropriate to retain, and that although the local government ombudsman was a route that could be taken, the local government ombudsman cannot determine whether a council has breached the code of conduct or not. They can merely confirm if the council has acted appropriately and whether there's any issues around maladministration. So it decided that the appeal process would be retained and that any appeal would be to the monitoring officer. There was also a review of the sanctions that could be imposed under the previous arrangements, and again we reviewed what other authorities had in place and used that as a starting point for what we've proposed within the arrangements. We also sought advice from Eversheds around whether the sanctions put forward were appropriate. However, having attended a number of group leaders' meetings, the issues around sanctions were raised, and there was concern particularly around the use of council resources and the impact that that could have on a councillor. What's clear in the report and in the arrangements that any sanction imposed must be proportionate and cannot have the effect of a councillor not being able to function as a councillor. So in order to give councillors peace of mind, that provision has been added within the arrangements to make it clear that any sanction cannot have the effect of not allowing a councillor to function as a councillor. We also reviewed the separate procedures. I'm not sure, we have some previous members of our Standards Committee here, but I know that some people are new. So just to make you aware, under the old arrangements, where it was a councillor versus councillor complaint, it was determined by an independent member. Where it was a member of the public versus council complaint, it was determined by the Deputy Monitoring Officer, and if it was a breach, it would be referred to a subcommittee. The Working Party thought about whether it was appropriate to have these two separate procedures for the different types of complaints, and to determine that actually it probably wasn't appropriate to have two separate procedures, and that one would be much more consistent and easy to administer. So the question that the Working Party then had to look into was, what role will the independent members play, and is this a role that we want to retain as an authority? In considering the role of an independent member in the investigation process, views were sought from the Working Party on what would be appropriate. There are issues, as everybody in this room is aware, about independent members making decisions on behalf of the authority because they don't have the legal capacity to do so. As you're aware, this evening they're unable to vote. In the past, we've put processes in place to get around that, where it's effectively delegated to either the Deputy Monitoring Officer or the Monitoring Officer. However, following the working party's work, it was felt that the independent members brought greater level of independence to the process rather than just having an independent person, and that we could still use the legal workarounds with the DMO giving effect to decisions or the monitoring officer, and therefore it was decided that independent members would determine all complaints. One of the things that was identified as well is the need to make it easier for the complainant when they're making a complaint to know. So the amended arrangements appear at Appendix 2 of your papers this evening, starting at page 36, and you'll note at the back of the appendix is a flow chart which maps out, on page 49, which maps out the process, the new process that's being imposed, and that's there in order to assist the complainant and parties to the process. Following the work that's been made, following the work of the working party, Appendix 2 was formed. I will make you aware we had a very tight turnaround. We couldn't get to our last group meeting, which I believe was the Labour group meeting, I think was our last meeting. That was already scheduled in, and that was literally 2 days before our reporting deadline. So I am aware that there's some grammatical amendments that may need to be made in Appendix 2. I'm happy to take those this evening, but are aware that that's the issue. There was also some follow-up work that was undertaken by the working party, and we created a procedure for appointing independent members and independent persons, and that can be found at Appendix 3. We also reviewed the media protocol to make sure that it was in line with the new arrangements that we've created at Appendix 2, and a copy of that document is at Appendix 6. I will note that we've noticed an error on one of the sanctions on that, and that will be amended to reflect the sanctions that are in the arrangements. That's just an error, I'm afraid. The recommendations are as set out at paragraph 2 of the report on page 1. And as you will see, we have a mix of recommendations, some for Standards Committee and some for full council. So the first, recommendation 2.1.1 is that we appoint Standards Committee approve the independent persons and independent members appointment procedure. Information packs have been included in the paperwork just to show you what is proposed, and these are working documents. The revised media protocol as to Appendix 6 needs to be approved by the Standards Committee. The remaining items under the recommendation are recommendations to full council, and once approved, full council will be considering those on the 22nd of October. I'm happy to take any questions, Chair, or assist in any way I can.
Thank you very much. That's a very helpful overview of where we've gone, and I'd like to take this opportunity to thank members of the Working Party who had beavered away at this over the last couple of months. Obviously we had the hiatus of the election and then the consultative meetings after that, but obviously a great deal of background work has gone in. I think we'll come back to the recommendations in a moment, because they are in a sort of very strict sort of order, and a sort of illogical one in a sense. What I'd like to do is to focus your attention first of all on the new arrangements, which are beginning from page 36, because that is immediately pertinent to what Mel has just, the ground that she has just covered. At one point I'd like to go through on a page-by-page basis just to pick up the small typos and so on that you referred to. But before we do that, can we take points of principle on the arrangements themselves, on the new proposed arrangements?
You want me to kick off, Chair? Okay, I've got about 7, I think. And I'm not just going to be... I'm doing it as we've noted them. Page 11 of 86, 6.1. It was therefore decided that the time limit would be subject to exception at the discretion of the Deputy Monitoring Officer. We would like to suggest that as the discretion of the committee, or perhaps the chair of the committee. Moving down to 6.4. sentence, it was therefore decided that the time limit would be subject to exception at the discretion of the Deputy Monitoring Officer. So if I move down to that it's at the discretion of this committee or the committee in the absence of an appropriate meeting, the chair at least. 6.4. I think this goes to the point that Mel was making about length of time. I think we're concerned that there doesn't appear to be anything done if we're running on it's not being resolved. So I'm not quite sure how we escalate it, but probably we escalate it again up to this committee or the chair of this committee after 3 months if it's not been resolved. 6.4 that is, page 1186. Can I move on? Yeah. Thank you. Over the page, 6.6. It's certainly a very firm view that an appeal should not be conducted by an individual, but should be determined by an appeals panel constituted under this committee. That's in the middle of 6.6, the bottom 5-6 lines up. It was also suggested at a group meeting that. So not the monitoring officer or deputy monitoring officer, but an appeals panel. 6.6 sanctions, 6.8 sanctions. We are, based on what Mel said earlier, you still got 2, possibly 3, but certainly 2 sanctions in there which prevent a councillor being able to do his job. E and F, if they were imposed, would prevent a councillor from doing their job. So, I certainly couldn't agree to those remaining in the list of sanctions. And on I take advice, but since those appointments are made by full council, I think it's only full council that can take the appointments away from the individual. So that's 6.8 on page 6 of 11, E, F and I. Everybody happy to move on? Thanks. 15, page 15. At the top, H, again, we think there should be an escalation if there's... The top of page 15, letter H. Or page 9 of 11. Are you there? Yeah. It's under miscellaneous issues, H. The arrangements have been amended to so that either party fails to respond within 1 month. If they don't respond, then again it needs escalating, presumably. Well, I'm not quite sure where we would escalate that to. Again, I think probably the chair of this committee. 3 more. I'm on page 37 of 86, which is the document that the chairman wanted us to concentrate on. I think this is just a very simple matter. Some complainants may not be able to access the internet, so although you may say that when somebody rings up, if it's not published in the process, then they might not know what to do. So some statement in there explaining that a hard copy can be obtained by phoning or writing to.
That's on the meeting complaint.
Yeah, yeah. I mean, it's no big deal, but I think the others are the big deals. Again, over the page 39 of 86, halfway down, under informal settlement, 5.6. Again, appeal to the decision to the monitoring officer. I don't actually think we should be putting the monitoring officer in that position, having been involved in the process. And so, an appeal panel from this committee, and I've got no suggestions on how you constitute that. Maybe something for a later discussion. And pretty much the last one, 43 of 86. I'm just reiterating the point about appeals there. Section 9, 9.1 and 2. Appeal panel, not the monitoring officer. Not can I say that I have any, or we, the Labour group, have any issue with the abilities of monitoring or deputy monitoring officers. It's just it's seen to be as independent as possible, and that both those people can be involved. Difficult to show that they're not. That's all, Chair. Thank you.
Okay, thank you. Could you just clarify for me? Obviously, we did go back to groups, and I believe there was a meeting held with the Labour group. The points you've raised, are they new, or were they raised at the Labour group?
Yes, I think most of them were raised at the Labour group, except the issue of appeals. The principle that was causing some worry at the Labour group meeting was the issue of what prevents a councillor being a councillor, and they haven't been altered. And I see the proportionality paragraph is in there, but it doesn't make it any easier if the monitoring officer decides to take away the IT facilities. You're preventing a councillor doing their job.
Yes, I would like you to just comment, because, as I understand it, the meeting with the Labour group took place before this paper was put to bed. So, therefore, I imagine that your views were borne in mind in final drafting of this document. So, if you, in responding, if you could bear that in mind too, I'd be very interested to see where you're coming from. Councillor Friday.
Can we ask if there are any other amendments before looking at these specific ones and then going back and looking at them all over again?
Yes, okay. So anybody else who wishes to comment? Councillor Parker, then Councillor Mrs Agnew.
Thank you, Chair. The point I'm raising this evening isn't particularly out of my group, it's my personal readings of the papers. And I would like to question on page 38 of 88, where we have 3.5, comment about the investigation officer. Within the report, particularly appendices, we have considerable comment on the skills, knowledge and skills required of the independent lay members and of the independent person. But the important role of investigation officer merely makes reference to the fact that they may be, and I'd like to correct here 3.5 because it says they may be an officer. I believe if you pay further reference to paragraph 7.2, it makes reference to they should be a senior officer. And this goes on to say of the authority, and then it says an officer of another, and you need to insert authority there. So I think that paragraph needs to be amended to reflect that the appointment must be to a senior officer of this authority and also a senior officer of another authority. What I wish to question this evening, Chair, is there's no reference here to the fact of what qualification, knowledge or skills those persons bring to the position. We may obviously reasonably wish to make assumptions that they have those, but I think it's only fair that there should be something documented to that effect.
Councillor Mrs Agnew.
Thank you. Just two comments really. On page 13 of 86, slight concern about the fact that we can't stop, or the point about the stopping a councillor working. Are there not behaviours which, if councillors did, they would be actually suspended by the council? And in which case they would be stopped working? And surely, is it not a responsibility of the Standards Committee to actually highlight that possibility to the full council? Looking at, I kind of suppose it's 6.9. And the other comment is page 42 of 86, 7.5. I note that it's withdrawn after a period of time if somebody hasn't replied, which I think is perfectly right. But I do wonder if that should sometimes still be recorded, because certain complaints could reoccur. And in which case, further down the line, maybe that should be considered if another complaint of a similar nature came in.
Thank you. Well, that's quite a lot to address. So, Mel, do you want to take them in any particular order?
I was going to suggest, if that's okay with everybody, that we take one at a time. I give you my view, and then you can open it up for debate, and then you can make a decision on whether you go forward with that recommendation or not. So hopefully, if I pick up anything incorrectly, please let me know, because as the Chair said, there has been quite a few. So the first point that was raised is that the time limit discretion is at the... Yeah, so it's page 11. Well, what I'll do is I'll take you to the point in Appendix 2 rather than the point in the report, so that we can make sure we're amending the right document. So Appendix 2, and it's page 38. And it's the bit in Appendix 2, and please correct me if I'm wrong, Councillor Pierce, it's 4.2b. And it's a bit where it says the conduct complained about happened more than 6 months ago, and there is no substantial reason for the complaint to be investigated. And this draws from your comment, Councillor Pearce, made around 6.1, page 11 of the report. In terms of the time limit being at the discretion of the Deputy Monitoring Officer, one of the things that we're looking to do here is to speed up our process and to make this as simple as possible. There are already complexities in there that we have to work around, and I think it was just seen that if the Deputy Monitoring Officer could act as that initial sifting exercise, it means that we can deal with things promptly. And there is no reason, I mean, as some of you might be aware, but in all the other arrangements we've seen, it's the monitoring officer who determines complaints against councillors. So it's perfectly reasonable for the deputy monitoring officer to have this discretion to dismiss a complaint if it's less than 6 months, or decide if there's a substantial reason for the complaint to be investigated. My concern as an officer, if we add in that extra level of consultation, and I'm just being honest here, it will add in a delay factor within the process. And just to make you aware, we get a mix of complaints. We've got our annual report coming up a bit later on, but a lot of them are parish, a lot of them are quite relatively minor tit-for-tat complaints that we can now deal with promptly. And the reason that that's in there with the Deputy Monitoring Officer is to maintain that efficiency of the process. So those are my thoughts as an officer. I'll open it up now to you to comment, debate, discuss, and then we'll go forward with whatever recommendation suggested.
Thank you. Comments, please, if any.
My personal view is, Chair, that I don't see any problem with the monitoring officer making the decision in this respect. I think all the potential causes that would allow the officer to make a very easy and clear decision are listed. So I have no problem with that particular paragraph. Thank you, Chair.
I think I'm right in saying that there are only 3 people who've got actually legislation practicalities under the Localism Act, which is the monitoring officer, deputy monitoring officer, and the independent member, independent person. So really, this and striking out any other things are really against the rules anyway. So I would commend that we carry on with item B as being the deputy monitoring officer.
Yes. Lord sympathy to Councillor Pearce, because the Council, I believe rightly from the very first meeting 17 years ago, believed that a lay member, as it called originally, played a very important part, including I chaired it to start with because a lay member, etc. And throughout the whole of it, the Council, I take its right view of the independent person has got a valuable part to play. Main reason because we're independent, non-political independent. And I thought that going way back, the monitor officer did not make this decision. We made a decision, and I didn't see any delay in time-wise, because the list where the monitor officer can deal with A to I will practically deal with most cases anyway. And going way back, we had that little magical tick box, and but we were independent members. We actually dealt with these on a pretty good basis, quick basis, and got them out of the way. And there was no any I think members of the public and councillors thought that was the right way to do it. They appointed lay members to do it, and those lay members were actually doing it. I know that we also went on to the bigger stage where we had hearings, of course, but this was the first sort of weeding out, if you like.
Sorry, could I just clarify with you that you're referring to this item at stage 1? 4.2? Yep.
We would go through the first thing we asked ourselves is the complaint a council or not? It's one of the things that we asked ourselves. And we went through that, all those sort of things, like tit for tat, minor, etc. And I'm just believe that the independent members can do it. I don't see it should be any delay, because how long does it take to arrange to meet the three of us or whatever to go through complaints? But
Sorry, pregnancy brain. The only thing I would say in response to that is that this is an initial sifting exercise to make sure that we are using my resources of my team in the most effective way possible, and that's why this is down to the Deputy Monitoring Officer. So it's about how I can best utilise my team members to make sure that we progress this. And I know what you say about the independent member, but that does have a level in there that from my perspective just perhaps isn't necessary, and I said, and having looked at how other authorities work as well, but it is a matter for the committee.
Didn't work. I know I'm going way back, the good old days in quotes, but the monitoring officer was with us, sat with us, and so it was a joint exercise of going through it, sifting out with the monitoring officer input as well. So I'm certainly not suggesting that 3 or 4 of us just decide, oh, that's what we're going to do, and which unreasonably imposes a burden on the monitoring officer's team, etc.
Yeah, I don't know whether I'll say this anyway. By making the statement that you've made, Mel, has immediately made you partial, and it reinforces my view that it should be took back to the independent people.
I mean, I'm sorry, Councillor, I'm not sure I understand that point, but as Deputy Monitoring Officer, I have a role in this process, and of course I always approach that with impartiality, and there's no reason to suggest, given that I'm a statutory appointed officer who is appointed for the promotion of ethical standards for your authority, it is my role to be impartial, and that is what I will do. But obviously, I
want to prolong that discussion. It was merely the point that it was in terms of making your team work more efficiently, and that wouldn't be the priority. The priority would be, is there a substantial reason, whatever that was.
I completely understand that point, Councillor Pearce, and you are right in terms of that, but the one thing I would say is in looking at efficiency, it's about making the investigation process as seamless and efficient as possible. So although, yes, I take on board that point, I am talking in terms of my own management responsibilities. It's also incorporating the aims of the working party in terms of reducing the time to deal with complaints.
Chair, having heard the point of view that's been put forward by Chris and Mel's response to that, I was definitely on the understanding that the main thrust of this was in terms of speeding up the process. Now, I definitely cannot then align myself to this significant change in the process because of, as Melanie put it, to better use of that department's resources. So I will now go back on my initial comment, and listening to what's been said, I don't want, as a councillor, to take away the important role that is provided to this process by the independent members. And listening to the points made by Councillor Pearce, I will actually agree. I think this does need to be, if in actual fact there is no evidence in past experience where the use of a panel made up of independent members has dragged out the process, then I think that should remain.
I actually go back to the early days of the Standards Committee when it was formed and remember the tick sheets, etc., which we used to complete at the time. I don't recall there ever being a delay caused by 3 of us or 4 of us meeting to do that. And I actually seem to recall we rejected quite a few, and there weren't any complaints that we found justified. So I would actually support the original way we worked.
I will comment further because this is quite a substantial change, and one thing that I will say, what people are talking about this evening is what used to be the Standards Assessment Subcommittee, and that was the legal requirement that we had a Standards Assessment Subcommittee to sift through, act as a post box for complaints. If you look at the way we've drafted our complaints process now, the only point at which we have a subcommittee is when we go to hearing. Now it's designated to an independent member alone. I think to ask me as an officer to bring in a subcommittee type for the sifting of complaints will impact on the efficiency of the process, because it will have to convene a committee of 3 members. You've still got the position where independent members can't technically make decisions on behalf of the authority, so it's still technically me who has the authorisation to make it. And I'm just worried that, I'm sorry to be blatantly honest, that will slow down the process significantly, having to draw on a subcommittee. And previously in 2012, it was this council's decision to remove the assessment subcommittee and to go forward with what we have in place at the moment. It was determined that the assessment subcommittee was a barrier to dealing with complaints more promptly. So it is a big change to what's being proposed. I stand by my initial thought, and I apologise if me talking about resources of the team wasn't the appropriate way to answer that. But as a deputy monitoring officer, it is my responsibility to maintain ethical standards of this authority. All other authorities across the country, the monitoring officer determines all complaints. We've adopted a different approach here, and I think there has to be a bit of flexibility there to allow the deputy monitoring officer to ensure that this process runs efficiently and smoothly as possible, and this is part of that. So I think for me, if we're going from, is it me sat at my desk looking at a letter, a complaint, going through this process, sifting, or is it a case of calling an assessment subcommittee, that is quite a big change and will have an impact on the process as driven.
Can I just bring this down from the stratosphere? What this is saying is what we were concerned about in the past was the complaints that used to come to us, which were 12 months ago, 18 months ago, 2 years ago. And what this is simply saying is that in the normal course of events, we will no longer consider complaints about events longer ago than 6 months. And that is the guideline that is being used here. Only exceptionally will that be exceeded when there is an important point of principle to be investigated. So I think maybe we're going too far in in pushing this, or the further implications that you're reading into it. I don't know if other members of the working party want to comment on that point.
Losing my voice, Jim. Thank you. I'm right behind Melanie on this one. I think she's right. I think we're on a bit of a hook here. There's a side issue about resources efficiency and such, and that's right, but I don't think it's the main issue. The main issue is independence, and I don't have a problem in this room with Melanie's independence that she brings to decision making. I wouldn't want to go back to the old system. I wasn't part of it, but it does seem a bit heavy-handed to have a panel of 3 independent members judging whether a complaint should go forward or not. If you're going to have anything, you just have one. So I would like to stick with what we agreed at the Working Party. I think it's the right way forward. I don't have a problem with it, and I think Melanie is the right person. If not just Melanie, any office holder is the right person to carry this forward. So I support Melanie.
Yes, Chairman, I certainly wasn't thinking about bringing back the assessment subcommittee. I think Peter's sort of saying you just need one independent member. You just go through, click, click, and the more I think about it, and maybe we did it before, maybe I should have thought of it before, but by asking, not Melanie, but a monitoring officer to do something, she's halfway down having decided whether it's a complaint or not, a worthwhile complaint or not, by having go through this. I mean, it's clearly, we know quite clearly that if you no longer account, that's outside anyway. But some of the things are a value judgment on the complaint. And I just think that an independent member, I'm sure one of us, can quite easily get in there within. I know the monitoring officer got the final decision, theoretically, with advice from an independent member, but I'm sure one of us can be in there within 24 hours or so, say, okay, let's go through this one, or if you've got several there, and we'll deal with it straight away. So you've got that. I certainly wasn't suggesting the old-fashioned assessment subcommittee, and we'd formally minuted it and put it in and do that sort of thing. But I just think that members will be much more comfortable with an independent input, let's put it that way, not decision-making, because I think Melanie's saying the independent member cannot make a decision.
What am I missing here? Because there's no value judgments involved in this. It's saying if the incident happened more than 6 months ago, then it won't go forward.
No doubt, I think through the discussion, the debate, there's an agreement to be had. But this is not a definitive list. That's potentially possibly the issue. These are suggested reasons why the monitoring officer will say no. And so therefore you have to make allowance for the fact that a complaint that is received at some time in the future does not match any of these criteria from A to I. And therefore that may well be, as Chris has suggested now, might be that you could modify this by saying these are the circumstance in which it's agreed that the monitoring officer will have control. In the event they don't fit any of that criteria, the complaint doesn't fit any of that criteria, then we could have maybe somebody else joining in that process.
So the discussion is now widening to the whole of 4.2. Is that right?
If you want to widen it, that's fine. That wasn't. Wait. Well, what I want is an independent member to determine whether there's a substantial reason. That's all. And we could go on, couldn't we? Well, what do we mean by substantial reason? In my professional life, if you're 1 minute after 12 at an application of a tribunal, then you don't, on the time limit, it doesn't get heard. It just doesn't get heard. So maybe we should be going down that road, because that's the example that's set by as close a judiciary as you can get to this process. If it's over 6 months, end of. And we would be happy with that. Or you have an independent person, because there's a judgment call. That's all. but I actually prefer the 6-month stop. But
well, I think we need a proposal, and the thing is that the only people who can vote on the proposal are borough councillors.
I'm not at the proposal stage yet, Chair, but I want to be certain that I've been engaged in the same discussion. The 6 month is only one of the criteria. It's not in the main paragraph. So we need to be clear. It's only one of a number of criteria.
Yes, so now we have come to, I think, certain agreement. I agree what Peter said, that to go along with what Mel is saying, and I'm going to really propose that we go to the recommendation and see what we can do. But I am also very much about the 6 months that Councillor Parker, Stewart, or Councillor Pierce actually suggested. So I think this is what we should be really looking at. Mel, can you just comment?
Okay, so there's firstly the first proposal that's been put forward is that 4.2b should be amended to say the conduct complained about happened more than 6 months ago, full stop, is my understanding, Councillor Pierce. So are you proposing that?
yes, I'll propose that.
No, you can't. Yep, speak up.
Thank you, Chair. Right. Sorry, okay, right, I see the situation we're at, and just to get it right in my mind, is a solution, is a wording that where the complaint happened more than 6 months ago, the Deputy Managing Officer is entitled to dismiss the complaint, and all other points likely to be this list, the Monitoring Officer with consultation with a independent member would make the decision. Is that the sort of compromise? There's a clear-cut, definitive 6 month, you're out, and then the rest with one member. Is that a compromise? Well, I'm sort of sounding out in my understanding that that might be what comes out as a proposal.
Is that a second proposal that we're having?
Well, it probably for us to move on, then yes. Why don't we say that?
Anybody
Sorry, I just want to check the proposal. I want to make sure I fully understand it before we have a decision on it. So at 4.2 of the report, it says that the Deputy Monitoring Officer acknowledges the complaint, and in certain straightforward circumstances, the Deputy Monitoring Officer, and the suggestion is that it's amended to, in consultation with an independent member, is entitled to dismiss the complaint at the outset. Is that what's being proposed? So just that addition to in consultation with?
Well, with just the wordsmithing to say if it is clearly out of 6 months, then we don't need you to talk to someone to say, look, it says it's out of 6 months. Do you agree? That's a clear-cut argument that it's either out of date, so that's one thing where it could be a decision, that the other decisions follow those points but in consultation with a member.
Chairman, I come back. The important thing here in this paragraph is the complaint. is likely to be dismissed if. And I think you don't really need to have anything after more than 6 months to go, because you stop there, because what you're saying is likely to be dismissed. I think that's what we all say. I think I totally agree that 6 months, I think, is probably the right thing. But we also know historically that sometimes something very unusual comes up. I think, well, maybe we should like it. But if you just stop at the end of 6 months, we're not saying it will not be accepted after that. On all those paragraphs, we're saying it's likely to dismiss if, and therefore the monitoring officer with an independent member is a different issue. But I think 6 months is fairly enough. But I think the monitoring officer or the independent member must have that slight flexibility for the unusual circumstances, because that's why the other bit, there's no substantial reason to be investigated. That's sort of, you're putting in as well.
Sorry, the difficulty.
Right. I agree with the intentions to ensure that the process is as swift as it possibly can be. We have had circumstance where I believe councillors have experienced considerable time factor stress in the length of time a case has been taken to arrive at a judgment. A to I on paragraph 4.2, I can't see personally, they are very straightforward categories, understandable and easily for a monitoring officer to make determination against. It's the other, it's the possibility of something not being within that I am more, that's what I am majorly concerned about. I personally am quite content for the monitoring officer to make the decision in relation to A to I. But I think it's where anything comes outside of that, where you may want, perhaps, somebody else to be overlooking the process, independent.
Just one comment I would make. I'm not sure if this will help or hinder, but it's worth a shot. When I investigate these complaints, I have quite often been known to give an independent member a call on something that it's actually nothing to do with them and they're not involved at that particular point in the process. But I have quite often given Liz, Peter or even the chair a call and said, look, I've just got this complaint, what are your thoughts on it? So if ever I felt that I wanted that second judgment call, I have that ability, because of our independent members, to go and already seek that kind of assistance and support. You know my views as Deputy Monitoring Officer, that I feel it's perfectly acceptable for me to take these decisions, but I'm just expressing to you that I approach this very practically, and if I need to consult an independent member to get that independent view, I do utilise them and have utilised them in the past. I worry about putting in a consultation requirement with an independent member. I don't think that's necessary, but again, as I said, it's a matter for this committee. And it is your point, Councillor Parker, well, what about if anything comes outside of this? I'm not sure what could, because this is my guidance, and this is from experience what we've drawn up. Now, we all know with complaints, every complaint is different, but if it was something off scope, then it may be that I would have that conversation and use my own initiative to bring that conversation on. So I'm not sure if that helps.
We have two things going on here. One is to actually get a proposal together, which is understood by all. Secondly, because we are a peculiar committee, the Standards Committee, the majority of people in this room cannot vote on that proposal. The only people who can vote on that proposal are borough councillors. Therefore, that's why we're struggling a bit, purely procedurally, at this point in time. If I put the proposal together as I think it's come out, then I'll hand over the chair to Councillor Putty, who will take it through with the borough councillors. We've got a proposal that 4.2 itself, the main introductory paragraph, is amended to say, in certain straightforward circumstances, the Deputy Monitoring Officer, in consultation with an independent member, is entitled to dismiss the complaint, and in addition to that, subsection B is terminated at 6 months ago. So it reads, the conduct complained about happened more than 6 months ago, period.
Yes, Councillor Parker.
Does that mean you're not giving the Deputy Monitoring Officer any discretion in terms of whether she approaches an independent lay member?
That, as I understand it, is the proposal from the floor. But the monitoring officer will be the person that makes the actual final decision in consultation with rights to make it.
Yes, from what I understood is that
Yeah. So
Deputy... You'll second that. It's proposed and seconded. So, councillors, all in favour? Yeah, unanimous.
Thank you. That's your first point.
Right, moving on. Right, just give me a few seconds just to find the relevant bit in the code. So the next point that was raised relates to paragraph 6.4 of the report, and this is about suggested period for conclusion of the complaint. And this is paragraph 6.2 of the arrangements, which I've accidentally ripped my page out. Here we go. So 6.2 says, if the councillor subject to a complaint fails to respond to the correspondence, the complaint will be determined. If the complainant fails to respond to the if the complainant fails to respond, the complaint will be treated as withdrawn. Usually this action will be taken after 1 calendar month has elapsed. All parties are encouraged to respond promptly to any correspondence in relation to the complaint, and all parties will be kept regularly updated as the complaint is progressing. So the discussion topic is that it's recommended that if the complaint isn't resolved within 3 months, that it's escalated to perhaps the chair of the Standards Committee. In terms of my comments in relation to that, it will be as the complaints are going to be determined by independent members, referred to as independent standards assessor, it will already be an independent member who's progressing that forward, but I'll open it to the floor for discussion.
Chairman, I just don't see it, and I think that paragraph must be completely correct. You're just saying, if you don't get your backside, it's thrown out. And I think comment about some of the complaints we had have gone on for a long time. Most of those is because somebody involved in the process has not done anything, and that's what we're saying. Do it, or you've lost it. And I think that is perfectly right. The wording on the paragraph.
I can live with that, Chair.
Is that not the same though as 7.5, where we're saying that although it can be withdrawn, it possibly needs to be recorded? So does the same apply to that for future if something came up again?
I think that's a separate point about whether to record it, which we'll pick up later. I think the point that we're looking at today, at the moment, is should it be escalated, or is the word in the paragraph 6.2 appropriate? I think Councillor Pearce has just said that, having heard what Chris Evans has had to say, he's happy to accept it as worded. Okay. Happy to move on?
When I say a new member to this committee, I mean the thing is it doesn't meet that frequently. So I was at the last annual committee meeting, so you'll please bear with me. The one thing that I want to try and understand in this, and there are similar paragraphs, but I'm not going to quote them. We're dealing with here if somebody doesn't get into gear and get the paperwork dealt with. Where's the buffer in the case of somebody suffering illness that causes that delay?
there isn't a buffer within that wording that I've just read out to you, but obviously it would be unreasonable if we, well, it depends, it does depend, because you can have people who are avoiding correspondence by claims, but if it was a genuine claim, then I would hope that we would act reasonably and accept that. What this is about part of the delay caused in the investigation process, in fact a considerable amount of delay, is getting the parties to actually engage in the process. So it's about making sure that we do have that position and say, well, if this complaint is important to somebody, or if this subject member is concerned about this complaint, then it's in that person's interest to ensure they engage in that process. But I do take your point that if, for example, somebody became very, very ill, then that might be one that you would apply an exception to. But that would be a very, very rare circumstance.
Sorry about this. In the past, when I've read some of the reports on complaints, case history, they have been quite sad in terms of possibly it's involved bullying, potentially individuals getting very upset with other individuals. And you do have then the possibility that a person's ability to cope with the paperwork, face the facts, deal with filling out forms, presenting their case. So I feel that it needs to be something. This is all about, also, we've got to deal with equality in terms of individuals' abilities to deal with that type of event. And I think it's not fair for things to be saying, you go back to, if I, in memory, go back to the process where the councillor being complained about has 10 days to return the paperwork, to complete the paperwork and return the paperwork. But there's no, I don't see here anywhere where there's any allowance to somebody suffering an illness and not being able to meet the time criteria. So I don't know how you're going to work that in, but I think it's a very important fact.
Mr. Chairman, doesn't the word usually give sufficient discretion in the circumstances?
I think it's helpful to just sketch in where we have come from. I appreciate what you're saying, Councillor Parker, but there have been instances where there has been week upon week, month upon month, where there has been no response, either from the subject member or from the complainant. And I think the working party in putting this forward is trying to maintain the momentum. You know, in other words, we haven't heard from you for a calendar month. I can remember occasions when Mel has frantically been trying to contact people by telephone, by email, maybe on one occasion going round to the house, I don't know. But you know, that is where we have come from, and what we're trying to do in this new arrangement is just to ensure that the momentum is maintained. I agree with Councillor Fryer that there is a certain amount of flexibility built in there already. It's indicative, but there's flexibility in there in the use of the word usually. Did you want to add? Right. I thought we were at the point where Councillor Pearce was withdrawing that proposal, but it seems now that this thing has wings.
I thank my colleague for pointing out usually, and I can accept.
Thank you.
So if we're ready to move on to the next item that's been raised in this evening, and this relates to appeals, and I think we can take this as a general issue. I think there's various points in the process where appeals are referred to, but I think we can take it as a general issue. So please correct me if I'm wrong, Councillor Pearce, I think the point was raised that an appeal should not be dealt with by an individual and that instead an appeal should be dealt with by an appeals panel. So again, I will give a bit of background to the working party and my professional opinion on that, and then I'll open it up to you for discussion. So in terms of the appeal, so the appeal is to the monitoring officer. This is the monitoring officer's only involvement in this process as it's currently drafted, and I've already explained about what happens at other authorities. As you're aware, following the work of the working party, we looked at whether it was even appropriate to have an appeal, and actually at one point it was discussed that we might not have an appeal. So that's why we've decided to retain an appeal. Your monitoring officer is your statutory appointed person for ethical standards, and as I said, often, well, in every other complaint process across the country, the monitoring officer determines all complaints. So it's felt from the working party that that's why the monitoring officer was the appropriate person. So that's the background. I'll open it up to the floor for discussion.
Thank you, Chair. I'm comforted with the fact that it does say with the independent person. And I see no reason to make any amendment to that.
Any other views?
Mr. Chairman, I've read it several times and I suddenly realised that the independent standards assessor will have made the original decision, and then for whatever reason, which the appellant will have to give reasons, then goes before the monitoring officer, fine, but then it's an independent person. Why an independent person? Why not a totally different independent assessor?
The reason for that is obviously our independent persons are crucial to the independence of our process as well and have an important role to play. They are legally required to be consulted before a decision is made. So hence why the independent person has to be consulted. We don't want to overcomplicate this process anymore. If we bring in an independent member as well at this stage, it's just adding an additional layer when you've got your independent person there who can assist. So the reason it's the independent person is because the legislation requires us, before we make a decision, to consult an independent person.
I just want to come back, Mr. Chairman. Will the independent, so confused, person have been part of the decision-making process anyway? Because quite often my decision making that we've consulted the independent person, or the independent person has been part of that process anyway.
Whatever process it's going through, an independent member must be consulted, because as I said, they are a statutory appointed role that has to be consulted before a determination is made. Pardon? What did I say? Member? Oh God, sorry. Independent person has to be consulted. I've lost my trail of thought now. I've forgotten what we're saying. So an independent person has to be consulted. It's statutory, and that's why it's in the process.
Mr. Chairman.
Councillor Pearce, do you want to come back on this tour?
Mr. Chairman, could we not just say that the independent person is not the one that was involved in the original complaint hearing decision? We have more than one, so we could actually just say it's a separate person. Many other appeals, like you do at governors, you have the people who weren't involved in the original decision hearing the appeal, so that would seem a sensible way forward.
That's all right. I mean, that makes sense, and that's the natural justice process that I think we were making clear there, so I'd be happy with that. No.
Come on, it's my last evening committee. So just to be clear, there was never an intention to use the same independent person who dealt with the complaint in the first place. So by adding in a different independent person, that was what was intended anyway. So is that agreed by Borough Councillors, please? Yeah.
So just to be clear, that'll be in the paragraph 9.1, won't it, in the paper? So that will be the monitoring officer will determine in consultation with another independent person. Is that how it will read? Yeah? All right. Thank you.
Right, so moving on to the next issue that was raised, Chair, and this is in paragraph 6.8 of the report, and this relates to the sanctions that have been imposed. Councillor Pearce raised the point that he felt that the sanctions as drafted still prevent a councillor from being able to do their job in relation to 6.8E and 6.8F. He also made the comment in relation to 6.8I that removal from outside appointments is a full council function, therefore was this appropriate? There's been a lot of discussion around sanctions and the effect that a sanction may have. Sanction E relates to withdrawal facilities and makes reference to IT facilities. I contacted the IT department to get a bit of clarification around what that could look like and what that could be. An example might be is, say for example, we have a situation where a councillor is harassing an individual member of the public and using their council email account to do that. We could, under this sanction, block that email address from the councillor's internal email. So we can do that. So we are not talking about blocking access to a councillor's email account, because I accept that that would prevent them from functioning as a councillor, but there are other things we can do. We can also block access to internet sites and those sorts of things. Now, that isn't to say that the councillor can't pick up their own computer from home and do whatever they want to do, but it just means us as a local authority are able to have a little bit of control over what that particular councillor does or doesn't do. In relation to item F, exclude councillors from a premises, I take on board the point that it would be wrong to exclude a councillor from premises. For example, this evening, councillors are having to attend committee meetings, and that is part of your role as a councillor. However, if you have a situation where you have an allegation from an officer that they feel bullied or intimidated by a councillor, and that it's appropriate to prevent a councillor going from an area of the council premises, then that may be appropriate. And I'm talking extreme behaviour here, and I'm having to give examples that hopefully will never happen in this organisation, but those are the types of things we're talking about. So those are my comments in relation to E and F. In relation to point I, very valid point, Councillor Pearce. I think that that would have to be worded that the committee would recommend removal from, rather than at the moment remove from. So that's a very valid point. So I'll open this discussion up to the floor, and if you need me to add in, I will do.
Chairman, who's somebody who feels pretty strongly about censures, some of the good censures we're not allowed to do anymore, but that's the fact. I believe that you should just stop at D. And the most important thing that we have, because don't forget, we have no right to we, I don't think as a committee, have rights to take anything away from the councillor. If in C, you report the finding to the full council and make recommendations to the full council, then you can put all those things in like GHI or whatever. But I think it must be the full council that makes any decision in any case. And the example that Mel is making is quite right, but that should be the full council making a decision, having had the report from the Standards Committee or Standard Hearing, and not just report the findings, but to make recommendations of possible sanctions of that sort.
Yes. Yeah, I hadn't quite considered it in that sense. And I think I probably agree with that on the basis that it's highly unlikely. But it came very close the other year, didn't it? Without naming names, but I think those of us that have been around will know who I'm referring to. And I don't want to go into the rights and wrongs of that, but it did come very close. But it hasn't happened since. I'd be happy to finish at D, frankly. That makes sense. And you'd say report the findings and recommendations to full council would be, that would tie that off, but, other people might have a different view. I'm sure they do.
Chair, I just wondered how often full council are sitting in relation to this. So is this going to cause another delay in the process?
I think this is such a difficult topic, you know, and we're really saying unto whom is a councillor responsible? And at the end of the day, there's no getting away from the fact that the people they're responsible to is the electorate. And the electorate can't get rid of a councillor by themselves, even if they raise a petition signed by everybody living in the ward. It just can't happen. So I think to suggest any sanctions that could be followed without reference to full council would be a mistake.
Just to be clear, full council have no more legal power than the standards committee. So full council don't have the power to suspend a councillor anyway or take any more action than a standards committee can take. So just to be clear on that, so if it is referred to full, the only difficulty I've got is if you make a recommendation, if you say this is a decision of the standards committee, we're making the recommendation to full council that these actions are taken, that's fine. But if what I think you need to be careful of is that it's not full council who are taking the decision on those sanctions, because that wouldn't be appropriate, because they've not been sat at the hearing, they've not heard the evidence, they've not had everything before them. So I just think you need to be quite careful about what you're seeking to achieve here and what you've got with your wording.
No, I'm okay. It's all been sort of dealt with. Thank you.
Come back. You know, let's be realistic. The council is the political cockpit that you have. This whole thing, and there must be a huge problem with a councillor who is in front of the full council with a full report in front of them, and the full report will have been made after all the evidence has been heard. And in front of all the other councillors, and you're in fact saying that on the evidence that we've heard, you, the councillor, have done something wrong. And I think that's a far more powerful weapon than many things. Otherwise, why do we make a full report to the council? You know, I just thought this was part of the process on it. You may also say, of course, that the press has published the whole report. That's true, but I think you probably get more publicity anyway, which does the councillor no good at all when it's heard in front of a full council meeting with the possibility of political input.
I'd just like to say that the possibility of the recommendation that goes with the full report and the findings to the full council is probably resolves my question about are there not certain behaviours which actually should be reported to the full council that has happened, that they are serious enough to be doing so. And in which case, to my mind, the incorporation of recommendations in that finding is sufficient to sort that out.
Yeah, I'm moving even further away because nobody can enforce any of these. It's pointless. It's absolutely pointless. Well, you can't. You just can't. The only thing that would happen, and it wouldn't happen to Chris because he's an independent, is that the whip would be taken away, or the party would expel them, and they'd have to become an independent until such time as they're re-elected. But Mel's right. You can't do any of this. So, get rid of it.
Obviously, we're here to promote and maintain high standards, and you are right. You have no enforcement provision, but the hope is there that, you know, at the end of the day, as councillors, you're acting for the interests of your community, and actually sometimes it's the pressure from community more than this. But I think I have to support the process as Deputy Monitoring Officer, but I do acknowledge that you can't enforce the sanctions.
The only other thing I would say is that in the working party, when we were looking at this area, we did consult quite widely, looking at other authorities, and the sort of list of sanctions that you see there are in current use in other authorities. So in making up your minds now whether or not you wish to endorse this particular line that the working party has taken, or if you wish to amend this in any way, then I need a proposal from the borough councillors.
I'm going to leave it here now. By way of a question, really, I think the G is quite acceptable. There's no reason why there can't be a recommendation made to the group leaders. It is only a recommendation. It's giving a steer. One that I find puzzling for me is H. I don't know where that sits, what's the driving force behind it, and how on earth you would hope to achieve it.
I'm not really sure much. In terms of H, I mean, the background of that one is again what we've picked up from other authorities, and the only thing is it could go to council and it'd be for council to determine. It means that where you've got somebody in the place as executive leader, that there would be a recommendation that they should no longer be executive leader. The leader of the council, yes. Sorry, executive is... Apologies, executive is probably... No, it's the correct word, but it's a legal word. So, for example, what the leader does is an executive function. So I hope that's not what's causing the confusion the lawyer's drafting.
Chairman, this has been through all the party, all the groups, group leaders, etc. And they have made their points, and members here have really voiced what is more or less they see of concern. But what we have to really make, we have, the working party has worked very hard on it to come up with what we have got. And if I think our borough councillors will agree with me, then we go ahead with what we have. And then if it comes in the years that these things doesn't really apply, we can look at it again, we can review it. But currently what it is that a lot of work has gone into it. It has gone through the group leaders and the groups. And now we are here tonight just to see whether we can adopt this. So would you like me to ask the councillors whether? So can I just ask the councillor that can we go along with what we have got?
Mr. Chairman, we've already decided that I needs to be amended anyway, because we couldn't determine it, but we could recommend that the councillor be removed from. So that wording probably just needs a tweak before you even decide whether you're going to accept the lot or not.
With that particular tweak, can we? Oh, Councillor Parker.
What concerns me is that through the discussion that we've heard the point made, I didn't hear then any disagreement, that a lot of this can't happen. There's no process. So 6.8, the hearing panel can recommend the following sanctions. Well, who are they recommending them to? I mean, some say they recommend it to the group leader. The other doesn't say where they're recommending it. And the point was made that possibly it should be the recommendations are made to full council. But you see A, censure or reprimand, B, publish the findings, recommend training. Who are you recommending? That to the individual councillor that they accept training? Well, okay, maybe that's something you can do. And in order to, as it were, draw a line under the complaint, they would go and find some training. But I don't think, as Councillor Putty suggested, this can go forward exactly as this. There's got to be some agreed changes to it, the wording at least.
Just to make one comment, I mean, I think enforceability, that's a national issue. I think what's important is a borough council, we're seeking to promote high standards, and in seeking to promote those high standards, it's appropriate that we have all the tools available to us to enable us to achieve that. In terms of the sanctions you've got before you this evening, you can impose one or more sanctions. So if you decide that a recommendation for training is appropriate, you can still request that that's reported to full council. So it's not as though they stand in isolation, it's not a tariff system or anything like that. You can impose one or more of those sanctions. What the Working Party have done is look at, well, what sanctions are out there? What can we use? And this is what we've come up with, and this is around promoting and maintaining that high standards. The enforceability is a national issue that we, I'm sure, address at some point later on, but I don't think the fact that the concern over lack of enforceability should affect what sanctions we decide to impose.
Sorry, in that case then, does it not mean that the first sentence just has to say the hearing panel can recommend one or more of the following sanctions?
Thank you, Chairman. As a member of the Working Party, can I slightly go back on what we agreed? I was never, to be honest, entirely happy with the some of the sanctions that were proposed, and I know where they came from. Is there a possibility to stop at D, but in C, insert something along the lines, report the findings and any recommendations to full council? And those recommendations, if thought necessary, would subsume anything from E onwards.
Yes, I think that's what Chris Evans mentioned earlier. We need to get to a point of having a clear proposal, but Councillor Tomlin.
Sorry, it was just I've just gone forward into the media section that I know we're looking at later, but it lists them in a slightly different way, and it is wrong. Well, it has a very good word. It says sanctions available to the independent member and the subcommittee are. So that sort of thing, saying these are available to the committee as opposed to it's just adding that they are available, as we've just said. So some of the wording is already more clear, I think. Yeah.
I think to include sanctions that everybody in this room and everybody in the chamber will know can't be enforced is daft. I mean, you know, in an employment tribunal, you can't force an employer to re-employ a dismissed employee. They might then suffer a greater fine, but you can't force them to re-employ. And we've got a situation here where if you withdrew some facilities for a councillor, he or she could quite easily take action against this council for not allowing him to do what he'd been elected to do. And that goes to the root of the democratic system. So I can't possibly agree with anything beyond D in its current form.
One thing I would say is that we've talked about stopping it at D, and that you can report to full council and you can add in whatever recommendations you would like. But from my perspective, the subject member needs to be clear about what the consequences could be of their failure to breach the code, and I don't see why we shouldn't specify those. Well, I'll deal with your point in a moment. I'm dealing with this point first. And I don't see why we shouldn't specify those so it's clear to the hearing panel, the subject member and the complainant what the potential consequences of the breach could be. In terms of the enforceability, as I said, that's the national position. That doesn't mean as a local authority that we shouldn't seek to have high ethical standards. If you as a councillor have a standards committee decision that says recommends training following a breach, then as a councillor and as a publicly accountable position, it's in your interest to comply with that recommendation. And I think that failure to do so has a public effect. And I will say that you know, across the board, there's one authority where a councillor has committed some quite serious breaches and isn't complying and is causing no end of trouble for the local authority because they're in this position. But most of the time, people do comply with the sanctions. The provision around the sanction has not changed. We had disqualification before, but we had the same issues around enforceability previously. And when we've determined breach at hearings, we have had one occasion where a councillor didn't comply, but councillors have complied with those sanctions because it's in their interest to do so. And just because something is potentially not enforceable doesn't mean that we shouldn't seek to promote and maintain high standards across the borough and recognise that where a breach occurs, that a proportionate sanction is appropriate recourse for the subcommittee.
I understand that the purpose of the function, this is the Standards Committee, but the inference that people who put themselves forward for public service are only going to behave themselves or engage in high ethics purely and simply because there are sanctions to be applied against them is something that I find distasteful.
I don't think it's about, I can understand why you could perceive it that way, but that isn't the point that I'm making. It's about what a comment is that's been made is that, well, these aren't enforceable, so let's just not bother. Well, I'm sorry, but if that's the point, well, why are we bothering with the whole process? The point is, if you're going to create a process, you need to create a workable process. And although when we talk about maintaining high ethical standards, we expect that of our councillors anyway, but if they don't comply, we should have the resources available to us to be able to take proportionate action. So I apologise if you've taken it that way, as though you think I'm coming in with a sledgehammer to crack a nut, possibly, we'll have these sanctions and people will behave. It's not about that. It's if you have a process in place, everything needs to be proportionate in that process.
Just a moment. We've had one sort of go at this. Councillor Putty put a proposal to the floor, or to the borough councillors, which did not fly. If I could just summarise where I think we are, and then I'll come back to you, Councillor Parker. Looking at 6.8 itself, one suggestion is that we should amend the end of the opening paragraph. So it reads, the Standards Working Party concluded that one or more of the following sanctions were appropriate. There seems then to be, we've also agreed that I will be amended to something like recommend removal from all outside appointments. But where we seem to be coming a little bit adrift is how far down this list we should go and how that should be drafted. It seems as though going down to about D is acceptable to most people. And then there's whether or not we continue with those or tweak them slightly so that they're more acceptable, or whether we amend C to say something like report the findings and recommendations to full council or parish town council, and the recommendations will then be taken up of something like E to I. I think that's roughly where we are, and we need, in light of that, to have a proposal that we can, when I say we, I don't mean collectively, but the borough councillors can vote upon. But Councillor Parker, what did you want to come in on?
Sorry, I've got it again. 2 points I want to make then. I first of all wanted to ask, this is the new process. What was the old? On this particular element.
It's on page 34 of 86, paragraph 6.8.
And your second point?
Where we've got the list that we were talking about ending at D, I have no personal problem, as I said earlier, with the G. And so therefore, if people would want to move G up and make it the E, I think that's the idea here is that the process can be helpful. And I think that in some sense, the outcome of the hearing may be a cause for the panel to make a recommendation that because of the nature of the complaint, that the group leader considers removing them from a particular committee. And I think that needs to be changed to not committees or subcommittees, from a committee stroke committees.
Sorry. I mean, take out E and F because they certainly didn't appear previously. I agree with Councillor Parker on G. I also agree that H is, recommend to the council. That would be legitimate to recommend to the council, but the council would have to vote on it. And I, we've already said that we would in fact amend that. So, in the light of that, as long as we delete E and F, I could be happy with the rest. And I'm sorry if that seems, that I'm not supporting high standards, but I note that the previous doesn't go as far as that. And I just think there is one small problem on G, Stuart. That is, if it was an independent, there wouldn't be a leader necessarily. If they weren't part of the independent forum, as we have an independent councillor at the moment, don't we, who's not part of the independent forum, but that's where it is today.
Yeah. Do we have a proposer among the borough councillors? Would you like to say something?
I just pose this question to the borough councillors, in that, as has been the case, that a councillor has been misusing his council computer by looking at paedophilia, that under this situation, the person could continue to look at paedophilia through the borough council's IT system if no action was taken. And I think that this is I think there is a current case about. So I think that also that if, as Melanie mentioned, if in fact a councillor was abusive to officers, and as Councillor Pearce has mentioned, a past member who was abusive to certain members of the borough council, to exclude them from the borough offices as opposed to the borough, as opposed to the various council chambers which the various parties have access to, that may not be appropriate, but it certainly must be appropriate to be able to ban them from sections of the offices if they're abusing staff. So I think that in both cases there is a very good reason to keep them there, and I think that if we you take as was referred to the Lords chap, there is still a person in the Lords who refuses to resign, who has not suggesting he had paedophilia attachments, but he just said, put two fingers up and said, I'm not resigning. And that's appropriate, and that, I mean, there's nothing you can do about it, but I think there should be sanctions nevertheless in those two cases.
Mr. Chairman, I understand that the councillors sign an agreement for the use of IT, and there is a code of practice that is signed. So the mention of what they were doing, which is inappropriate, is already got a sanction on it that there is a code of practice. So they have broken the council's code of practice by using it for the reasons that they shouldn't be. So I don't know whether there's any sanction in the code of practice that councillors agree to when they get given the IT, but presumably the whole point of it is that it could then be withdrawn from them anyway. But that might be quite an interesting conversation to be had with the IT people.
Yes. Okay. I think both of those interventions are very helpful. But we do have, I think, a clear proposal on the table for borough councillors to consider, and I would urge them to sort of bear those last two interventions in mind in looking at the proposal. If I summarise it for you, and then you can take it from there, Councillor Putty. The first part is, as I said, in paragraph 6.8, at the end of that it should be amended to read that one or more of the following sanctions were appropriate. The proposal now before you is that E and F should be deleted from that list, that there will be a slight amendment to G, which should be removed from a committee or committees. I'll ignore the point about independent members at the moment, but that was mentioned in passing, and also that I should be amended to become a recommendation. So I think that is the proposal in a nutshell, which councillors have to consider now.
Can I ask councillors whether with these amendments and what Chairman just said, is that something that we all agree? No? You all agree? Councillor Parker?
We are talking here of recommendation. Keep going back to that, don't we? It's a recommendation. And I've listening to our colleague in regard to there are circumstances, there's no doubt in my mind that there are circumstances where it would be desirable because of behaviour for the full access. We discussed this in our group, and I think at the time we raised this particular point, saying that we didn't want complete loss of IT facility. And this says clearly here limiting. But our view was that it would be very difficult for a councillor to conduct business in the current times, because a lot of people, their casework comes through on emails and the like, and they access information and do research. And to exclude the councillors from, but the point made is certainly important in regard to pornography. Excluding the councillor from council premises, again, if they remained on a committee, despite the findings, they would have to come into the council, but this does say part of. It doesn't say the whole building. I think it's been worded reasonably sensibly. One I said I had issues with, and I think that's been covered, is the committee recommends I, as Councillor Pearce made the point, it's for the council to appoint and remove people from outside bodies. And I don't understand, again, I still just don't understand H. So my view is modified from the discussion that we've had, and I don't particularly have any problem with E and F or G. And I remaining with the modification. I don't think there's, sorry about that, but there we are. It's a discussion we're having.
Thank you. Yeah, I tend to agree with Councillor Parker, I have to say, on that. In my heart of hearts, A, B and C are the most relevant. And that would do enough for me. Once you've published that you've been naughty, I think the world has a way of sorting you out. So I'm happy to go with Councillor Parker, which was not the recommendation that you were putting forward. Yeah.
So from what I understand, what's been lost is the removal of E and F. There were the point. Well, let me work through the other two minor amendments. So the first one, are we satisfied with an amendment to one or more sanctions may be imposed? The second point that we're picking up on is the wording in paragraph G that was proposed by Councillor Parker to A committee. Agreed?
Yep. Well, they can be one of the, it's A committee, stroke and committees.
Okay, yeah.
Councillors are, as most of us here tonight, are members of more than one committee.
Okay, yeah.
It might only be relevant. It might only be relevant
to one
through the source of the complaint. That there is the, you know, a head-to-head with the chair or the other committee members. That it's that committee that they have to be sanctioned against.
So is that amendment agreed? And then the final amendment, and please correct me if I'm wrong on this being the final amendment, which I believe is agreed, is the amendment to point I, which is recommend to council to remove. Is that agreed? Agreed. Excellent. So if everybody's happy, I think we can move on to the next item on the list of things raised.
I did say I have concerns over H.
Yes. Do you want to address this, Councillor Parker?
Yes, I would like to. I don't understand. I'd like somebody of the working group to explain to me what was the thrust behind including that. It's very specific. We're talking here removing the council leader in those terms. I would think if the council leader has done something that comes with it, there would be a motion to council of, I forget what it's called, no confidence in the leader. And that would be the way that would actually happen in the democratic sort of forum. So I don't understand where this is. I don't see why this is so bad. Why don't we then say, well, I'll add to this then. Why haven't we got something that says recommend to council that the councillor is removed from the cabinet? It's not there. Why the leader?
I think it's a legal technicality point. I think that this is drawn from other arrangements, as we said. I think the point that you make, so full council has the authority to remove the leader where there's a vote of no confidence. However, in terms of the cabinet is appointed by the leader, and the leader has the authority to appoint the cabinet. Council doesn't have any authority over the appointment of cabinet, and I think that's why that's the difference, I think, in that particular point you've made. In terms of the background of it, please, working party members, do step in, but it's just something that came up as part of the sanctions that we found from other local authorities used across the board.
The point, though, would be correct if we were suggesting that a chair of one of the policy committees or the scrutiny chair would have to be a motion to council to remove them because they're appointed by full council. So I'm agreeing with Stuart. We can't just leave that at executive leader. Council appointed positions.
We could add those in. Yeah.
Can I just use the general term appointments made by council? Or? Okay, so are we happy to move on to the next point?
Yep.
So I think the next point we've already covered, but I would just like you to check, Councillor Pearce. So this is page 15, item H, and this just double check, yes, so we've already dealt with this. This is where the party fails to respond. So moving on, page 37 of Appendix 2. Councillor Pearce raised the point about explaining that a hard copy could be obtained. I think that's a useful suggestion. Is that agreed by borough councillors?
Agreed.
Excellent. Page 39 deals with appeal. We've already dealt with appeals. Page 43 also dealt with appeals, so we've dealt with that. So the next issue that's raised was by Councillor Parker, and this is in relation to paragraph 3.5. Just get that in front of me. It's on page 38, paragraph 3.5, and there was there was one addition there, which was the addition of the reference to senior officer. And I think, please correct me if I'm wrong, Councillor Parker, you said about what would be the qualifications of that individual. I haven't considered the qualifications of that individual. I have quite a diverse team. I have different levels within my team. I have solicitors, legal executives, paralegals who can carry out this role. A lot of those are used to assessing evidence and determining things. One of the things I would say is that the investigator prepares the report, but then they forward that report to the independent member. So if there's anything that's lacking in that report, the independent member can say, go back and I want you to look at this aspect or that aspect. So the qualifications will be legally qualified at various levels. In terms of, obviously we've given there the scope for an officer of authority or an external investigator in case that I don't have the resources. I don't want to delay any process if my team hasn't got the capacity to assist in this matter. And where that tends to be done, you do find that tends to be the legal professionals who carry out that role. So it will either be a monitoring officer, deputy monitoring officer of another authority, or we've had a solicitor in the past has done an external investigation, and historically we had a barrister as well that did an external investigation. So not something that I have specifically thought through or specifically referred to the working party on, but it will be somebody with a legal background.
The point I was making was that if you turn to page 56, and you can see that other parties that are involved in this process, there's a considerable and very well thought through set of skills to be applied. And I think there's no reason why then there shouldn't be some clarification of this. You've now given us that clarification. This is a working document. This is the document that everything's going to be referred to, particularly when we're going outside to other authorities. In this instance now, we may not have that control, and we should therefore be making it quite clear to other authorities who we are expecting to be appointed. You've now clarified that these will be officers from within your team. It doesn't say that. It just says a senior officer of the authority. And I think the investigation officer is an equally important role as any of the others. And so I do urge you to carefully consider mapping out what that CV will be.
Okay, if it helps, I mean, can we just put in something like of a recognised legal qualification? Because you've actually illustrated that. Would that be enough?
That was actually the main point I was going to say, just say suitably qualified. Sorry? I was just going to recommend suitably qualified be inserted, which is the point that I was.
That's agreed. I'm happy to add that in. I really don't mind. Officers with a recognised legal qualification. Agreed? Go on.
Has it always? Are you saying it's always going to be from your team? Because there'll be other officers in another department who will have a recognised professional qualification, which would, in all probability, lead you to think that they could conduct an investigation.
If it's internally, so obviously we do have the option in there of another authority or external investigator. If it's internally, it will always be from my team because the function is with my department. Okay, so moving on then, and this I think was raised by Councillor Mrs Agnew around 6.9. And was this the report, Councillor? This is the point you were making that we said we were going to pick up on. I'm just trying to find out. This is the point we were going to pick up on around notification of withdrawals. So we've talked about if somebody fails to respond within 1 month, and you suggested that there should be some sort of recording of that. Do you want to just provide a bit more information?
Basically, I agree with the statement that it's going to be withdrawn, but what I wonder is if there are particular types of complaint, for instance something like sexism, racism or those kind of complaints, that although it's been withdrawn within a month because somebody hasn't replied, if another instance of that came up, then perhaps we should have recorded that as it's a repeat complaint, and therefore it actually puts a different light onto the subsequent complaint.
One thing I will say is regardless of what's gone before, each complaint is considered on its own merit. So even if we had a previous complaint, we wouldn't be looking at that when we had a live complaint coming in. The only time you can consider previous complaints is when you're looking at sanctions. In terms of record keeping, we keep a record of all our complaints within legal services in accordance with our retention schedule, so there will be a record of that complaint.
Shall I just come back on that? I'm fully aware, obviously, that you do on its merits, but Mel's saying it's reported, any pre-cons are reported before sanction decided. I think that's the first time I've heard it actually said that we will. I've always thought we should be, but there's nowhere in the procedure saying that, you know, that any previous matters will be reported to the appropriate before sanctions are decided. I think it's very important actually if you have a repeat offender. You know, obviously, it shouldn't be part of the decision making whether there's a breach or not. But having heard there's a breach, then surely you should also know that this person has had a number of complaints against him or her.
I think you're right. I don't think it is in the arrangements. I think it's just a common legal interpretation that's been taken forward, if that makes sense. But there is nothing in the arrangements to confirm that position that I've just described. It's a legal point.
Chair, now I'm slightly worried because if we're going to include that, then it's definitely got to be in the process as to what point is that previous sanction spent. And that's certainly, you know, my background in employment law is always there, and each employer chooses within their procedures to maintain that. But it's also there in general law, isn't it, that you know, you have to declare certain things, you don't have to declare other things. So I'd be very nervous about trying to set a whole new set of tariffs up. I like the first response, which is each case is treated on its merits.
Yes, I think where you're referring to is page 47. This is the hearing panel procedure. And really it comes around 6.7, 6.8, 6.9 on page 47. That will be the place where usually it's the legal officer who would give advice to the hearing panel at that stage of their deliberations. Mel is just pointing out to me 6.5. The hearing panel finds failed to follow the code. They may consider representations from the Deputy Monitoring Officer and or the subject member as to whether any action should be taken and in what form. The hearing panel will also consult with the independent person. I think, it's whether or not we wish to just inject a sentence there to cover this point within that area. Yeah, if you want to propose an amendment, do, otherwise we'll move on. Yeah, what I want to do now is to go back to the beginning of the paper B, and if we look at 2.2 first of all, because we've been going through the new arrangements. 2.2.1 says the arrangements for dealing with complaints at Appendix 2 are adopted. What I would say that the arrangements for dealing with complaints at Appendix 2 as amended in the light of our lengthy discussion are adopted. Can I have your agreement to that?
Well, I should say regrettably not, but I can't vote. I'm sorry I didn't get in earlier, but Councillor Pearce had a lot of valid points, and you're going through that. What I'm concerned is the informal settlement, page 39. Could I suggest, well, I would suggest there are amendments. 39, informal settlement. The principle of informal settlement is obviously the right way to do about it. He was trying to resolve that. Therefore, 5.6 needs to go, because why should any party be agreed with the decision making? Because you've agreed it. And the agreement wouldn't be made unless an informal settlement has been agreed. And also 5.4, subject complaint, the complaint is accepted. That's not fair. A part of an informal agreement may well be that the complainant may accept that it's not. The council was acting okay. Now I think you should delete 5.4, delete 5.6, and 5.5 should be amended where any informal agreement is made. You then go on to say that's the subject of the agreement of the independent person, whatever. But I think you're sort of having always, when you know, one's got to part of the informal settlement's got to be the council's got to complain, got to apologise, and when somebody says you've got an informal settlement, which to me means a settlement, in other words it's been agreed, you say, well, if you don't agree, you can appeal. Oh, sorry.
I think, and please working party members do correct me if I'm wrong, I think the reason that was added in because generally you would hope that an informal settlement is agreed, and that is the aim of a formal settlement, but if both parties are putting forward, or one party is putting forward a reasonable settlement and another party won't agree, it actually gives the independent standards assessor an opportunity to say that the informal settlement is reasonable in all the circumstances and they're not going to progress the complaint any further. So say you have a councillor who comes along and says, I don't know, I'm probably going to say the wrong thing tonight, but say you have a councillor who comes along and says, you know, I apologise for what happened, I didn't intend it, and the complainant says, no, I'm not willing to deal with this by informal settlement, I want this to proceed, and blah, 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 blah. And what you've got in 5.5 is the standard assessor having the power to say, well, actually, that's a reasonable informal settlement, and it's in the interest of all parties involved for it to be settled at this stage. So just to give you the background, really.
But that's not what it says. It is desirable that any informal settlement is agreed by the etc. etc. They will then proceed to the next process. You seem to be saying is, well, if somebody puts what the independent person thinks is a reasonable offer, and the other one says, no, I don't want that, that's not an informal agreement. That's not an agreement in any way at all.
I'm not sure there's anything I can add from what I said. It is desirable that it is agreed, but there's provision in there if it's not agreed that the matter isn't progressed and it's the independent standards assessor who would make that decision.
you know, it's contradiction in terms. You're saying, well, if it's not agreed, they can take a decision. I accept that, but that's not where it's written. It says, if it is agreed, they can do that on there.
So your proposal is to take out 5.4?
Well, I mean, it may be that you're looking at a different way, but 5.4 I don't think is fair at all. You know, at all. You're in effect saying, well, you've got to accept your apology or not. May accept. Well, if he doesn't accept that, then there won't be an informal agreement anyway. So also, you may well be that the complainant also agrees some other action. Well, I come back to the principle, as far as I'm concerned, an informal settlement is a settlement agreed by both parties. And I can see that the independent person taking a view on, well, you may have agreed that, but we think probably not right. This is not. But if both parties agree, then that's agreed, and therefore it cannot be appealable.
Yeah, if you want.
I'm not sure it says that. What I read in here, unless I could be wrong, but was that I agree with you, Chris, that if there's an agreement, there's an agreement. But I think this is saying if there isn't an agreement, that the independent person can say, well, I'm satisfied that that would be an appropriate agreement, and the informal settlement does the job, is what I think it's trying to say.
In fact, it says where the independent person is satisfied that the informal settlement is reasonable. Well, in effect, they said, we think it's okay, and by the way, what the independent person, what do you think? Yeah, we think it's reasonable as well. Why do you then move on to say, well, somebody's going to not accept that? Because all parties, complainant and the independent person, seemed, as it's written here, are satisfied. You know, mainly, if what you're saying is a different view, then it needs to be rewritten.
Chair, I think you could probably get over this by where it says is satisfied that the informal, but is satisfied that an informal, rather than that the. Well, I'm on 5.5, fourth line, commencing appropriate, ending informal. It is satisfied that an informal settlement is reasonable, because we're talking about one or other parties disagreeing, not having an informal agreement. But if the independent officer says, I think it is very reasonable, and it's that word, the informal settlement, and you're quite right, it's bad English.
I think the word settlement is a much better word than an agreement, because you're quite right. Settlement may be that in the terms of the independent person, they believe that's the way to settle it, that's fine. But I still think that the 5.4 is a little unfair.
The only thing about 5.4 is it's just to give an indication what a councillor could do. It does say may. It doesn't mean that if a councillor doesn't accept that informal settlement won't work. And actually, where we've used informal settlement in the past, the councillors come along and said, well, actually, this is what I meant by X. Not, I apologise, I've breached the code, I've done this. But so that's just a may. They could choose to do that if they wanted to. It doesn't mean that if they don't, that we won't look at informal settlement.
Right. In that case, would the majority of people be happy with that amendment to 5.5 that Councillor Pearce has proposed? Is satisfied that an informal settlement is reasonable in all the circumstances, and no other amendment. Agreed?
Agreed.
Yes, back to recommendations. 2.2, first of all, that the arrangements for dealing with complaints attempts to, as amended, are adopted. Sorry, got my light on. Are adopted. Yeah. Are you content with that? Are you happy with that? Agreed?
Agreed, Chairman.
Thank you. 2.2, the authorisation is given to the monitoring officer to make minor amendments to the arrangements to ensure that they remain an effective working document. I think this was in the earlier version, if I remember correctly. Are you agreed with that?
I am, of course, I'm in agreement with it in principle. I think it's subject to being, if there is going to be a minor amendment, that minor amendment is notified to all councillors.
Thank you for that. So subject to that amendment, notify to all councillors. Agreed? Thank you. And then 2.2.3 is about the appointment terms of the independent members. Obviously, it's a rolling programme, 2 to retire each year, but not in subsequent years, so that there is maintaining the maintenance of continuity, and the similar principle in 2.2.4 relating to the independent persons. Are you happy with those proposals?
Agreed.
Agreed? Thank you. Right. We then go back, if you could, to the first part of the recommendation, which is 2.1. It is recommended to the Standards Committee that the procedure for appointing independent members and persons at Appendix 3 is approved. I hope you've had a chance to look at those in advance of this meeting. Are you happy with those procedures?
Agreed.
Agreed. Thank you. 2.1.2 is related to that. It's the information packs that will be provided to applicants for positions of independent members and independent persons. Are they noted?
Noted.
Okay. Thank you. And 2.1.3, we might have to have a little discussion on this, I think. I'm glad you stayed with us. The revised Media and Communications Protocol, Appendix 6, is approved. You will see that we have added into that the new flowchart, but certainly in my reading of Appendix 6, there were some areas of drafting that I was not that happy about. I don't know how other members feel on Appendix 6, or do you wish to chip in anything, Sarah, at this stage? Any other comments on Appendix 6?
Oh, sorry, chap. Yep, we noted earlier something with the where did yes, sanctions, and so I think it might need a bit of a careful rework over after tonight's business, really. So it's a difficult one to say approve it because it's got a bit of a redrafting, I feel.
Can we say something along the lines of approved as long as it follows in the entirety the arrangements that we have agreed between us, something like that? Would you be happy to agree on those lines?
In general, it's right. I'm just not comfortable with the listing of the sanctions, because we come back to the point that I've rather laboured tonight. Sorry? It's on page 71 of 86. That I've laboured tonight is that I don't know whether presenting those publicly in a press release would be the sensible thing to do, because as we've already understood, it might be difficult to enforce them if a councillor wasn't going to be upstanding and accept that they'd done the wrong thing, which I naturally hope that all members of my group certainly I would expect them to. But in the light of the fact that there may be those that don't, I'm just slightly concerned. So I'm happy to approve it, but I'd like some solace on how that will be handled.
I think we all share your trepidation about approving something that we're not totally happy that it's drafted correctly. So can we just get... Yes, if we lift the agreed wording from the arrangements and deal with that as a separate Standards Committee business.
Yeah.
Yeah. Agreed? Okay. In that case, I think that we have dealt with item 6 on the agenda. Thank you for your contributions, one and all. There is a proposal at item 7 for us to note the Standards Committee annual report, which is very brief. Do you want to say a word or two about it, Mel?
So this is just a brief report to update you on the activity over the last year. It's a good way for me to monitor how effective we're being and whether we are making those improvements that we keep trying to achieve. So from the period June 2014 to July 2015, we had a total of 13 complaints. Of those complaints, 8 have related to borough councillors. The complaints on average have taken over 4 months to conclude. I'm pleased to say that is down on last year's annual report, so I am very pleased to report that, but as we've said tonight, there's still work to be done, and I recognise that as a Deputy Monitoring Officer for the authority. The complaints we made into parish councillors have totalled 5, and there have been no individual applications for dispensations. We've just had the general dispensation of granting, so unless anybody's got any questions on that.
Only a minor one, that I'm now with you for the coming year, as opposed to Councillor Tilbury.
One of the points that the chair raised with me, rightly so, he said, well, what are we going to do with this document? And one of the points he did say is that we could look at putting it on the Standards Committee page on the website. It does need a few grammar errors that we will pick up, but that might be something that you want to explore this evening, whether you want us to put this up on the website. We could make the amendments, send it round to the committee, make sure you're happy, and then post it on the web.
I'd also like to think that we could advise the clerks of the parish town councils that it is found there, so that they can refer to it if they get any questions. I know it's very easy to put things up on websites, but people who might want to actively look at it need to know it's there in the first place.
No, that's a good idea. Thank you.
It's more of a question, really. I'm doing it. If a complaint comes in and it's found not to be with any substance at all, does the decision notice get published for that? Because I have to say that I would be opposed to that.
So under the arrangements, because obviously we're working with our existing arrangements until full council in October, so under our existing arrangements, if a complaint is not capable of being a breach of the code of conduct, or frivolous or vexatious, then it is dismissed and there's no formal decision notice that's posted on the web.
Yeah, I mean, there are some minor typos to be sorted out here, and I think we agreed that the sentence which refers to borough councillors, it says additionally there will be, but that should be additionally there are 4 borough councillors. We'll get the names right.
I'm not taking that one.
Breach of code items 2. If I wanted to find out what they were and the background to them, there's nowhere here that sends me to the appropriate place. Sorry.
If we were to post this on the web, then all the decision notices are available on the web and it would be on the same page.
Yeah, I'm aware that it's on the web, but you don't say that. You say about for information about the code of conduct, the complaints process, and the complaints form are on whatever there, but if I'm ignorant about it, maybe at the bottom it should be sort of saying details of the complaint or something, but you know.
Okay, happy to add that in. All right. Okay, that's item 7. Item 8 is really for your noting. It's 3 decision notices that have been published since our last meeting, I believe. Noted. Which I think concludes the business of the meeting. I would just like to say 2 things. One, our next meeting is on the 26th of October. And I'm sure that you will join me in wishing Melanie all the very best in the coming days with the addition to your family. And we look forward to seeing you back in due course. And I can say that now that your colleague is no longer here. So, ladies and gentlemen, thank you very much for your patience. Thank you for your contributions. I declare the meeting closed.